Do you want to talk to her about that?
I guess you just, Miss Burt, can you hear me?
Yeah.
So you're gonna need to come down to the court and turn yourself in. You have a felony warrant for your arrest.
For what?
Domestic violence third.
I haven't touched
know.
nobody.
Don't
I've been
want to talk
out-
about it today. There is a warrant out. You need to come down to the 54A District Court. I would do it either today if you can get in very soon or first thing Monday morning. The judge is not going to handle
Okay,
your
I'll
sentencing
be
until you're
there.
waiting on the felony warrant.
Okay.
All right.
Okay.
Okay, we'll note it in the file that you'll turn yourself in the next 2 business days.
I haven't COVID yet.
Okay, well, you still need to turn yourself in. We'll give you a mask.
Okay.
Thank you.
Thank you.
You're welcome. Am I done?
Yeah, I'm going to reset your sentencing because I want you in person now, okay?
I gotta
Okay.
take care of
Thank you.
You're welcome. You hear that? Keegan didn't lie. I have a felony warrant out for my arrest for assault.
Ma'am, you're still in the courtroom.
Sorry.
Yeah, you need to
I
remove
thought I
yourself.
turned it off.
Yeah, you gotta click leave. It's a red button.
I am doing it and it's not leaving. There
Okay, we're on the record in the matter of the people of the state of Michigan versus Trina Deering, file number 22-01391FY. Council appearance.
Chris Martin for the people.
Assistant Public Defender Sarah Donnelly on behalf of defendant Trina Deering, who's standing to my right.
Today's date that was set for preliminary examination. How we proceed today.
Your Honor, this matter is set for preliminary examination. People are prepared to proceed today. We have also offered a misdemeanor plea with 7694A, a non-public status. I believe that prior to making a decision on how to proceed, Ms. Deering would like to consult with some other legal counsel about potential collateral consequences for an ongoing family court matter and a housing issue. And so we'll be asking for a couple weeks, I believe.
Or a week, just, I think is enough for me to.
It'll be more than a week.
Okay.
We're on conference.
We can do September 1st at 9 a.m.
September 1st at 9 o'clock in the morning. Okay. Any additional matters for the record?
Nothing for the people. Thank you.
No, Your Honor, thank you.
We'll get you a copy of the notice, okay, ma'am? No problem.
He's still being brought up Smith's here though.
We call a call.
Your Honor, did you want to do Mr. Rodaboss probation violation sentence?
Okay, are you representing him in that?
Yes. No. And I am. Highlight. So you're happy about that? That's.
Yeah.
Were you guys in the night meeting? Yeah.
So was that.
No, it was all you did until night. We did a big change, you saw that, I saw that, you know.
Mr. Rodoboy wants to.
Yep.
On the record in the matter of the people of the state of Michigan versus Douglas Carl Rodaboff, file number 19-02445. Appearance, please.
Thank you, Your Honor. Assistant Public Defender Sarah Donnelly on behalf of the defendant Douglas Rodaboff, who's standing to my right.
Thank you. How are you, Mr. Rodaboff?
Very good. Yourself?
I'm doing pretty good. Today is the date that I reset your sentencing on a probation violation. I did get word from your probation officer that you did make the payment of $500. However, you have not enrolled in outpatient services or nor are you in MRT or on And also, there was a positive alcohol ETG on, it says, August 9th. So that would have been the day after we saw you last. So you should be expecting a new violation. Okay,
Yes,
okay. How did you want to address the court?
yes, thank you, Your Honor. In regards to his, conditions with, that require him to go to COGS, Mr. Rotobaugh reports that he does have the money to pay COGS to get started back up in his programming. He has left messages and he's waiting for a return call. Unfortunately, they haven't. They're hard to get a hold of over the phone. Because that's what he expects, is to make the payment over the phone. That's how he did it last time. He knows that there's online options, but again, he has to get a hold of someone to find out those options, and he hasn't. He's left messages and just waiting for the response.
Anything else?
Mr. Rotobaugh, did you have anything else?
No, ma'am.
Thank you, Your Honor.
And the recommendation of the probation officer was to terminate your probation and impose jail time. See if it's just full of excuses that you're not willing to be compliant with probation. I'm almost inclined to believe that.
Say something, ma'am?
Well, yeah, I gave you an option before, you didn't want to, but it's up to you and your attorney if you want to address my belief in the belief of your probation officer. If you have anything that you wanted to share. Okay. Can I extend your probation at this time? You did at least make a payment, and it sounds like you're making efforts to get enrolled in the programming that was ordered. And obviously, I mean, there's a new violation that's pending at this point. I'm gonna extend your probation for 6 months at this time. Need to enroll in the programming that you were ordered to enroll in. Gonna give you a review date. I want you to, I'm actually gonna require that you check in every 2 weeks for a review date, because obviously I don't think you have the ability to self-monitor yourself for too long, because you're not doing well. This is your last extension. The next time is you're going to jail. Okay? You're held off on doing that because you owe over $15,000 to the victim. So you need to be working so you can pay them, but you haven't been doing that anyways. So we could always move on if you just serve the jail time versus tying up all of these resources while you continue to violate the court order. You understand? So it's up to you. The ball's in your court. You're gonna be compliant over the next 6 months. Well, it's a little bit more than that. I think you're supposed to end on the 23rd of September. I'm extending it 6 months from that. So over the next several months, if you want to be compliant and you want to get on the right track, that's up to you. This is your life. I don't have a substance abuse issue, and I don't owe anybody $15,000. You understand that?
Yes, ma'am.
It's just to help you get yourself on track. If you don't want that opportunity, that's okay. We'll find another way to hold you accountable and give you an opportunity to figure out how you're gonna get yourself together, okay?
Yes.
Do you have any questions today, sir?
No, ma'am.
You can do your reviews every 2 weeks here via Zoom. I'm gonna give you your review date now for your next review. Can I get a date 2 weeks out? Probation. Okay, we'll do September 6th. September 6th at 1:30 will be your next review date, okay?
Yes, ma'am.
Any additional matters for the record?
No, Your Honor, thank you.
Okay, we'll get you a copy of your notice to appear. You can appear via Zoom for that, okay, sir?
Okay, thank you.
No problem. Who do we have here?
Joseph, am I pronouncing it right?
Yeah, she's here.
I'll find Mr. Martin.
Okay. Excellent. The interpreter can come up as well. For the record, in the matter of the people of the state of Michigan versus Joseph Wakiota, file number 21-03384FY. Council appearance.
Chris Martin for the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson, appearing on behalf of Mr. Wakiota, who's present and seated to my left, Your Honor.
Good morning, Your Honor. My name is Abdallah Mkoma. I am the interpreter.
Thank you. Can you raise your right hand? Do you solemnly swear or affirm that you will interpret in the matter now before the court clearly and accurately and not divulge confidential communications? So help you God.
Yes, Your Honor.
Thank you. You can put your hand down. Mr. Wakiota, how are you?
Young. How are you?
Did she answer that without interpretation? Is that what's going on? Okay, thank you. Okay, today was the date that was set for a preliminary examination.
Leo ni siku ile umepangiwa kwamba nakuja usikie habari zako.
I believe there's a request to adjourn.
Yes, Your Honor.
Ndio naamini kwamba wanataka wapeleke mbele kidogo.
Your Honor, it's a mutual request. He has some additional, I'll let Mr. Martin touch upon from our side. He's got some of the discovery. Prepare for an exam yesterday, so I need some.
Mwanasheria wako anasema kwamba yani kuna habari nyingine kwamba yani watu wanazidi hawajapata. Sasa hatuwezi endelea na hii kazi mpaka yani wanipe hizo habari zote ni ziko pamoja.
The people's witnesses in this case live in Nebraska. And I had communication with them multiple times this week. However, with the short timeline, I was unable to get them here. And the primary witness is 17 years old and cannot travel without an adult. However, she turns 18 in early September and will be able to travel and check into a hotel here in town without the assistance of an adult. And so we believe that under the circumstances, the best course is to adjourn this to a date after her birthday, which is September 2nd, so that she's 18 and can travel on her own.
Anasema kwamba ni kesi haijatokelea hapa, ilitokelea sehemu nyingine. na mwenye alikuwa mwenye shahidi hapo saa hii anatakikana kwamba ana miaka 17. Mwezi wa 9 ataeneza miaka 18. Akieneza miaka 18 ndio atachukua ndege, anaweza kuja hapa. Sasa huyu mwanasheria anataka kwamba hii kesi iende mbele mpaka huyu aeneze miaka 18 ili asifuatiliwe na mtu yoyote, akuje peke yake. Alafu amtafutie hoteli hapa, alale hapa, alafu aendelee na kazi.
And I will add before we conclude this phase that we are aware that Mr. Wakiota is in custody with a high bond. I will inform the court that it's the people's intention to dismiss count 1 prior to
Anasema
the
kwamba
exam.
tunajua kwamba msamaha
And in light of that, we expect
ana mali nyingi sana na anapenda kwamba ni kidogo apunguze kwamba hizo pesa yani umewekewa hapo.
And in light of that, we expect a bond motion.
Ndio kwamba anapenda kwamba nipunguze kabisa ili aendelee na maisha yake.
Okay, sounds good.
Your Honor, that is accurate. We do wish to make a motion to reduce bond. I believe bond is presently set at 100,000. Cash assurity, I believe the arraigned magistrate, when she was factoring the bond, took into account that there was a life offense that was a part of the original complaint, as the people have just indicated. That charge is being dismissed. A couple of things to point out, as Mr. Martin indicated, the alleged victim in this case is now a handful of states away. So there isn't any concern with contact. This is an old case that it's alleged to have occurred from 4 years ago. There hasn't been any contact between this defendant and oh, sorry.
Yeah, anasema kwamba hiyo bandi ilikuwa kama 100,000. Sasa kwa sababu kesi vile ziliendelea, ziliharibika, kila kitu ilikuwa kwamba wamepunguza, na kama mwanasheria vile alisema kwamba ni kidogo waweke chini, yani watapunguza, alafu wakutana hiyo masiku ndio kutaendelea kila kitu, sababu kesi yenyewe ilikuwa ya kwamba ni ya maisha yote, yani ilikuwa kesi mbaya sana.
And given that there has not been any contact between Mr. Wakiota and the family a number of years now, there was no concern to that. Mr. Wakiota does live in Detroit area, but he will appear for court. I would ask for a bond reduction, and the defense has no issue with the GPS tether will be placed on Mr. Wakiota today.
Mwanasheria wako anasema kwamba anamsamakia kwamba ni anaishi upande wa Detroit huko, anatakana kuja hapa na atakuja siku yoyote ala ndevu yake, ili afungwe tu mchuma, endelee na kuja hapa kwa ndevu yake, atoke kwa mahakamani, ili hii sahihi kwamba ni wamwambia wakuchunge hizo pesa unatakana utoe, wapunguze ili utoke nje.
The people do not object to a bond reduction. However, we would ask for a GPS tether if he's able to make bond.
Ndio, na mwanasheria kule anasema kwamba ni watu wale walikosewa hawakatai kwamba ni atoke nje, na hiyo mali yako kwamba ni shushwe chini, lakini anataka ufungwe mkamba ili ujulikane sehemu.
Okay, even with count 1 being dismissed, we will have count 2, assault with intent to commit criminal sexual conduct, 2nd degree.
Ndio kwamba hata kama ile ya kwanza iliachwa kwamba ni zile zingine, ile ya pili itakuwa inaendelea kwamba ni ile umefanya tatizo kwa mtu,
on a person to a 14-year-old child.
Kwamba ni kwa sababu uliendea mtoto ana miaka 14 peke yake.
The address I have here is an address in Nebraska.
Kwamba inaonyesha kwamba ni yuko sehemu mbali sana kidogo.
We have a language barrier as well, so I do have a concern.
Ndio kwamba pia kwamba lugha ndio kidogo shida.
Does he have any prior criminal history?
To my knowledge, none, Your Honor.
Kwamba anauliza mwanakari sharia kuna kitu tunataka tuanze, anasema hapana.
I don't think he does, Your Honor.
Na yeye pia anasema hapana, hajafikiria kwamba kuna.
What's his home address?
Tuambie.
I want to say it's 19th Street.
I'm asking him.
Huh?
What's his home address?
Sema address yako.
Address yangu ya nyumba.
Ndio.
Naonekana nilikuwa nikija kutoka
Okay, address ya side Detroit, sema address yako.
Niko kunani Clinton County.
Clinton County.
What's the address?
Anauliza address, namba za mlango na njia.
Ndio mimi nasahau. Legally we can. Ni jina kumwangalia.
Doesn't have an address in Detroit as far as I'm concerned. If
Donc,
we can't give you
present
one.
17 17 mileage.
Sasa unatakikana namba za mlango kwanza, alafu unasema history.
Ya saba nilichukua mimi nilikuwa ngani mgeni. Ilikuwa sijajua.
So I don't know the address because I was new when I'm getting pulled out from there.
Nilikuwa nakuja juu ya kesi.
So I came for this case.
Lakini nyumba iko mimi najua.
Yes, I know there's a house there.
Nijui kwamba jina.
Who's renting the house? He's renting the house?
Well, una kodi nyumba wewe au?
Nilikuwa naikala na nilifikia kwa mtu tutakuwa tunachanga na issue.
My friend, so we were paying. I
Tulitokea
was
na mimi
paying and
graph.
he was paying.
He's gonna stay with a friend?
Yeah.
How long has he been staying there?
Ulikaa muda ngapi hapo?
Mimi nafanya tu mwezi mmoja nilikuja juu ya kesi.
1 month for this case only.
Nilitoka Nebraska na kuja juu ya
I'm
kesi.
from Nebraska.
What's your phone number?
Namba yako ya simu.
Ipo 4 email 0
412 402
saba
75
5
55
5
98. Bado.
4
Ndio wanasema kwamba umesema 402. Okay. Endelea.
That's
I think I said it.
numbers.
I gave him a
That's
pen
not-
to write down on his.
Judge, he did give an address at the arraignment. which
No,
I did.
I want him to tell me his address.
Yes, Your Honor.
If he doesn't know his address, I don't believe he has one.
Okay.
Ndio kwamba anasema ninaweza mwambia, anasema pana nataka wewe useme address yako kwa sababu kama wewe ungesema inamaanisha huna address.
Hapana, niko na address niko mgeni ni juu ile
Yes, I do have address but I'm new to
inaandikwa
this city.
Kiingereza.
You said you need a pen so you can write it down?
Sasa unaweza andika chini nikikupa kalamu.
Kuandika
Yes,
neno.
pen.
Yeah.
Umeelewa?
I need the phone number too, because
Number
that's
simu.
not a complete phone number.
Andika.
Okay, well, at this point, I think that we have a concern. If you can't give me a phone number, you can't give me an address. I don't feel like you can reasonably find yourself back to this court all the way from Detroit, or you're even staying in Detroit.
Anasema kwamba ni kwa muda huu sahihi, kama unashindwa kunipa namba, unashindwa kunipa address, kwamba sidhani kwamba unaweza toka Detroit ukuja hapa.
I recognize count 1 is going to be dismissed. I think there still is a risk of
Kama vile mmesema kwamba ni hiyo ya moja itaiwacha, lakini ingine itakufuatilia.
there's still a risk that of his return to court is unlikely.
Ndio kwamba ni kwa kuambiwa kwamba anaondoke mpaka kukuja kwa mahakamani itakuwa ni shida kidogo.
This is a very serious charge in count 2.
Ndio kwamba ni sahihi wewe unakamatwa na ya pili.
I'll amend the bond, however.
Ndio kwamba ni iko bado unasubiriwa na hizo faili za kutoa nje.
I'm going to reduce the bond to $30,000 cash surety with GPS tether.
Ndio kwamba ni atarudisha, ilikuwa 100,000 sasa ameweka 30 na utafungwa hiyo mkamba kwa mkuu.
And he needs to provide the court with a address.
Na
and a
unatakikana
phone
ulete
number
kwamba ni address wapi hapa watu wa mahakamani
and phone number.
na namba yako ya simu.
Ndio.
Ndio.
Nashukuru sana mama.
I say thank you.
Niko na shida yenye inanikamata sijui kinini.
He doesn't know, he has a problem and he feels that he doesn't know why he's arrested.
Na nimepata madro iko nipiga sana.
Now,
Ndio magonjwa ya roho.
I got problem with heart problem.
Niko na sababu vitu. Unajua namba yangu tuna shangaa.
I know my number, but I forget it.
Sijui kwa nini mimi sana.
I don't know why I forget it.
Na ni namba nyingi na metreza.
And it's the number that I used to use.
Okay, your attorney can explain to you why you were arrested.
Ndio kwamba ni mwanasheria wako atakwambia na magonjwa yako yote unamwambia mwanasheria wako.
You were arraigned, so the charges were read to you, correct?
Ndio kwamba ni kila kitu umepatikana nayo, ulifungwa kwa sababu ulifungwa na hiyo shida.
Mimi balichani tola tu nisikulia problem gani.
I do not know what's the problem.
Banachana ndio maneno ya mtoto.
And they told me about a kid's problem.
Na japo ni maneno ile mimi sijui hata.
And it's a problem that I do not know.
Mimi nilikutanaka na bibi na ule bibi na watoto.
And I met the wife and the kids together.
Yeah, we're gonna stop because we don't want him to divulge confidential communication or anything that he doesn't want to be used against him. I'm assuming what he means is that he disagrees with the charges.
Hiyo kwamba inamaanisha kwamba ni kwa muda huu sahihi wataisimamisha wewe, haya umefungiwa kuyajua. Kwamba haya ulikamatiwa hujui.
Daniel aliniambia. Nishabanielezea.
I was told by the
tulishazungumza nilisamba.
And I talked to Daniel too, and I came to the court.
Nishaka sana.
You want to talk to your attorney?
Nishaka sana.
Unataka kuongea na yeye?
Nishaka ongea.
He already talked to him.
Okay.
Anajua problem yote.
He knows the problems.
Okay, sounds good.
Hapo sawa.
Anything else?
Nini nyingine unataka kuongezea? Siongee chochote. Nothing else.
Okay, anything else for the record counsel?
Nothing from the people.
Watu wale waliumizwa wamesema hawana kitu chochote.
Nothing else, but I will work with the jail and make sure he gets his medicine for the heart heart.
Absolutely.
Na pia kwamba naye atatumika na wewe ili upate hayo madai ya moyo wako.
When does the victim turn 18?
September 2nd, Your Honor.
Anasema anauliza kwamba huyo mtoto ataenesha miaka 18 mwezi gani? Anasema mwezi wa 9 tarehe 2.
I'll give you a new exam date.
September 15th. 9.
September 15th at 9 o'clock in the morning.
Judge, is there any way I can get another date? I'm being a jury trial that starting my morning with Judge Kennedy.
Sema kwamba ni waliotafuta hiyo tarehe hapo mwezi wa 9/15, lakini mwanasheria wako anasema ana leo nyingine.
I mean, what they
September 9th.
she's looking, they put what date she's going to be at the time of travel, so she's fine. September 9th at 9. Does that work?
I make that return.
Mwezi wa 9 tarehe 9. Mwanasheria wako amesema uko sawa saa 3 kamili.
Any additional matters for the record?
Kwamba kuna yoyote unataka kuongeza?
Nothing from the people.
Nothing from the defense, Your Honor. Thank you.
Thank you. We're off the record.
Umemaliza.
I'll be out to see you next week.
Hiyo kwamba hiyo huko kwa nje. Sababu shinda kusema
Hapana, sehemu niko mabadiliko niko mgeni. Mimi nateseka sana.
Waiter, they can put them on, or if they want to put them on, that's fine. Are we running Clemens? Wait a minute, let's not get him yet. Right, we're supposed to be running Clemens, is that correct?
We are potentially running Clemens. I need to talk to Mr. Austin about that one. We are for sure running Van Buren, and we're ready to go as soon as that one's ready. Van Buren.
Mr. Moore?
Yes,
Okay, your matter is not scheduled today before me. However, it appears you have a warrant before Judge Buchanan.
for what?
We're not gonna pretend to be surprised. You miss court a lot, so it probably has to do with you missing court.
I swear I got 3 court papers in right here and I'm looking at them. I ain't,
Were you owed, you said payments? Do you owe money on a case?
Yeah, but I asked her, when I came in the last time, I asked her, could I get an extension? I'm thinking they're giving me an extension because I had to pay the storage bill or they was gonna auction off our storage. So
Well, I don't, that's not, the file's not before me, it's before Judge Buchanan. Typically, if you are given an extension and you do not follow through on that, they will either issue a show cause, which they may have done that and you didn't appear, and then it will go to warrant. That's likely what happened. So you might want to log into her Zoom instead of mine, okay?
can I get a Zoom number?
Can you get a what?
Her Zoom number. I need a pen real quick. Mom, you got a pen? Yeah, I don't know, but sorry for that pain there for the. Good boy, for myself. Okay, so can I get the number?
Absolutely. Her Zoom ID is 201
201
362
362
313.
313.
And when
Okay.
you log in, you can let them know that Judge Simmons courtroom advised them that you had a warrant and you wanted to address it.
Yes, ma'am. Thank you.
You're welcome. Okay, and then Mr. Griffin is present, but it looks like there's gonna be a request to adjourn. Do we know where Mr. Nichol is?
I think you may be in front of Judge Ward, Your Honor.
Oh. Who are we calling?
I'd like to call Carver Smith if we may.
We're on the record in the matter of the people of the state of Michigan versus Carvis Smith, file number 22-02024. Council appearance.
Chris Martin for the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson, attorney on behalf of Carver Smith, who's standing to my left.
How are you, Mr. Smith? I'm doing well, thank you. Today was the date that was set for a preliminary examination. Are we able to proceed?
Your Honor, this matter is set for exam today. The people do not have an essential witness. We've not been able to make contact with that witness. We expect a motion from the.
Your Honor, at this time, the defense stands ready to proceed. We're here ready to go. Motion for to dismiss this case. We are aware it's without prejudice and people can refile it.
Okay, motion to dismiss will be granted. This matter, as indicated by your attorney, will be dismissed without prejudice. It simply means that the people can refile the charge against you if the necessary witness later makes contact with them and is ready to proceed. You would then have to postpone again, okay? Do you have any questions? Any additional matters for the record?
Nothing from the people.
Nothing from the defense, Your Honor.
Thank you. If you have a seat, we'll get you a copy of the dismissal, okay? Do we know what's going on with Edmund?
Same thing.
Okay. That's Mr. Austin's case.
It is.
On the record in the matter, the people of the state of Michigan versus Tamia Monet Edmund, file number 22-01995FY. Council appearance.
Chris Martin for the people.
Thank you, Your Honor, and good morning. Jared Austin, appearing on behalf of Ms. Edmund, she's present, standing to my right.
Thank you. Good morning, Ms. Edmund. How are you?
Morning, I'm all right, how are you?
I'm doing well, thank you. And today was the date that was set for preliminary examination, and my understanding is that the people are unable to proceed at this time. Is that accurate?
That's correct, Your Honor.
Mr. Austin?
Yes, thank you, Your Honor. At this time, I would move the court to dismiss this matter, understanding, of course, that as a matter of law, the dismissal would be without prejudice. I would ask the court to grant that motion at this time. Thank you.
The motion to dismiss is granted. It's granted without prejudice. If the necessary witness is ready to proceed and makes contact with the prosecution in the statutory timeframe, the prosecution can reissue the charge against you. Okay, ma'am?
Okay,
Do you have any questions?
no,
Any additional matters for the record?
Nothing.
Nothing for
Sorry.
going back, Ms. Edmund, Your Honor. Thank you.
No problem. We'll get you a copy of the dismissal in just a moment, okay?
all right, thank you.
No problem. And so we are ready on Van Buren though, or is Silverthorne here?
We are ready on it. Yeah.
I have not seen him, but I'm assuming he might be in the building.
I believe he's his attorney.
Mr. Silverthorne,
Yes.
you said he's with whom?
Well, I saw Mr. Silverthorne here and I believe that,
Maybe he's in another courtroom.
yeah,
I know.
Mr. Silverthorne is here. These guys. Should I write in the reason?
Yeah.
Oh, sorry. Today is my parents' 50th wedding anniversary.
Oh, wow, that's awesome.
Yeah, we're going to go down on Labor Day weekend and see them and, you know, the whole family together. Yeah, I'm going to go get Mr. Silverthorne.
Thank you. I'm trying to understand why this one is cool. Oh. We're on the record in the matter of the people of the state of Michigan versus Brian Beaumont Griffin, file number 22-01768 FY. Council appearance.
Chris Martin for the people, Your Honor.
Assistant Public Defender Scott Nickel on behalf of Mr. Bomar Griffin.
Today was the date that was set for a preliminary examination. I have a note here that there is a request to adjourn.
Yes, Your Honor. Mr. Griffin has another pending matter before the circuit court. And I think that the goal here is to combine these matters to come up with a global resolution. We believe that we'll be able to do that if we just have a couple of adjournments.
Mr. Nickel, you're okay with that?
That is, I have discussed it with Mr. Bomar Griffin, and that is how he wishes to proceed. It's my understanding the prosecutor on the case up in circuit court is out of the office until next week. And so my plan would be to reach out to her next week and try to make some gains towards resolving this case.
Oh, sounds good. So we will reset this matter for a few weeks out. September 8th at 9 a.m. Any additional matters for the record?
Nothing from the people.
Nothing from the defense.
Okay, you're all set, Mr. Beaumont Griffin. We'll see you on September 8th.
All right, thank you.
No problem. Mr. Van Buren.
This is Bill. Are you available for an escort, please?
On the record in the matter of the people of the state of Michigan versus Aaron Van Buren, file number 22-02017 FY. Appearance, please.
Chris Martin for the people.
Adjourning. Dwayne Sullivan from the Office of Public Defender on behalf of Aaron Van Buren, who is seated at council table to my right.
How are you, Mr. Van Buren?
Good.
Today's a date that's set for preliminary examination. Are we ready to proceed?
We are. There are a couple of preliminary matters. And the first is a stipulation as to venue in this case. I've spoken to Mr. Silverthorne about that, and my understanding is that for the purposes of the preliminary examination, we will stipulate that the premises the witnesses describe is at 311 West Hodge Street, and that is in the city of Lansing. The other preliminary matter is that Miss Wilson, who will be testifying in a few moments, is a young woman. I believe she's 17 years old at this point. She has a history, high pressure situation of panic attacks. We've talked through some strategies with her, including a squeezy stress ball, which she will have on with her when she's testifying. I told that to Mr. Silverthorne. But in the event that she is starting to go down that road and we start to see some of the precursors of a panic attack, we may ask for a few moments to help her collect herself.
Absolutely. I think there was previously a request for a support person.
And we have, we have Ms. Rogan here from our office. She's also brought Andrea Bidlack with her, who will not be on the stand with her, but will be in the court.
Okay, sounds good. Mr. Silver.
Yes. I have no problem with this test file, and I was in it, there is a support person. That's fine also, I just require that be able to see the interaction between the support person and the young lady when she's testifying.
Okay, so would you prefer that she sits over there closer to her, because I don't see how you can see her behind you? Okay, sounds good.
And I guess it goes without saying, but we do not, there's not a circumstance in which the support person will be a witness.
That's correct. That is
Okay,
correct.
sounds good. Any additional preliminary matters?
Nothing.
For the bench, just to make sure that, well, no, I guess there isn't anybody else in the courtroom, so, and also that there aren't any witnesses that have logged in on Zoom.
I don't have
Potential
anyone on
witnesses.
Zoom.
Okay. Thank you.
No problem.
Just here, and Ms. Van Latten is right here.
Raise your right hand for me, ma'am. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury? Yes. Okay, you can have a seat there. There's a bottle of water that's there, that's yours if you want it. There's a court reporter that's sitting directly behind you. Her job is to take down everything that's being stated here today. So all of your responses must be loud and clear. They must be verbal. She cannot take down head nods or shakes. She also can't write down mhm and ahs. So if it's a yes or no question, you need to respond yes or no, okay? If either of the attorneys make an objection while you are making a response, you would stop talking. I'll make a ruling on that objection, and then I'll tell you if you can give that answer or not, okay? Please state your first and your last name, spell them both.
Kira Wilson, KYRAWILSON.
Proceed, counsel.
Ms. Wilson, thanks for being here. I'm going to ask you some questions about something that happened in November of 2020. How old were you in November of 2020?
15,
When is your birthday?
January 26th.
And so on January 26th of 2021, you would turn 60.
Yes.
And I'm asking you questions about November of 2020. And I'm going to ask about an incident that occurred with a gentleman named Aaron Van Buren. How do you know this incident happened in November of 2020?
Because it was still fall. It wasn't snowing yet, but it was after Halloween. We had a party at my house.
After Halloween, was it before Thanksgiving?
Yes.
Okay, so sometime in that time frame. In November of 2020.
Yes.
She shook her head, she nodded her head. Okay, thank you.
So in November of 2020, did you know somebody named Aaron Van Buren?
Yes.
How old was Aaron Van Buren?
18.
What was your relationship with Aaron Van Buren in November of 2020?
We were dating. We were boyfriend and girlfriend.
Now, in November of 2020, did Mr. Van Buren invite you to his home?
Yes.
You remember where his home was?
I know it was close to a Dollar Tree and a Wild Bill's tobacco shop over by Hawk Island.
And that's Hawk Island Park in the city of Lansing?
Yes.
And why did Mr. Van Buren invite you over on this day in November of 2020?
He said he wanted to have dinner.
When you got there, who was there?
His grandmother, his brother, and his little sister.
How did you get there?
My mom drove me.
Did she drop you off?
Yes,
Did she stick around after she dropped you off? Did she leave?
she left.
So you go into the house. What time of day was it when you got there?
It was midday, maybe 11 o'clock, 12.
At some point, did Mr. Van Buren ask you to come into the basement?
Yes.
What happened when you went down to the basement?
We walked down and he locked the door behind us.
Before we get into it, can you describe what the basement looked like, just the layout?
It was dark. There was like a ton of blankets and stuff hanging from the ceilings. And it was the door to walk into the basement was in the bathroom.
Okay, and where do you? What type of space was the basement? Was it like a rec room? Was it a storage area? Was it a bedroom?
It was his bedroom.
So he lived in the basement.
Yes.
Okay, so he walks you down and he locks the door.
Yes.
What happened next?
We went downstairs and he said he wanted to show me something. And I said, okay. And then when we got down there, I asked him, what do you want to show me? He said nothing. And I was a little questionable.
Was anybody else in the basement when he was asking these questions?
No,
All right, continue on.
we were standing there for a second and then he came over to me and he put his hands on my shoulders. And I asked him what he was doing. He said nothing. Then he took his hands and tried to take my shirt off. I told him no. He said okay. And we went and he said, why don't we watch a movie or a show? And I said okay. And we went and sat on his bed and we watched a music video from one of the rappers that he listens to.
Okay. At some point, did he try to make physical contact with you again after you were watching that video?
Yes.
What happened at that point?
He brought on top of me and took my shirt off, and I said no, and I didn't want to, and he didn't say anything, and I tried to push him off, but I couldn't, and at that point he unbuckled my pants and pulled them down.
Okay. And when he unbuckled your pants and pulled them down, what happened next?
He forced himself into me, but I gave up fighting because I couldn't fight him off.
When you say he forced himself on you, did his penis enter your vagina?
Yes.
Did that continue for a period of time? Did you say anything to him about wearing a condom?
Yes. I asked him if he was, and he said yes. Because I didn't, even if it was gonna happen, I wanted to make sure I was okay afterward. And then after it happened, he ended up telling me that he was not wearing one.
And after that was over, he was no longer inside of you. Did you, what happened next? Did you try to leave?
I got my clothes on and I sat down because my mom had a set time where she wanted to come get me. As I put my clothes on, I sat down and watched some of the video while he laid in his bed. And I just sat there and he asked me if he could give me a hug.
Okay, did he give you a hug?
Yes,
Did you want him to give you a hug?
not really. But I didn't want to make it seem like I was.
What happened next?
He gave me a hug and then I ended up just laying there next to him and then he started taking my clothes off again.
And how long after the first incident did this happen, approximately?
About 10 to 15 minutes.
You said you started taking your clothes off. Did anything happen after that?
He ended up forcing himself inside me after he got my clothes off.
And when you say forcing himself inside you, again, is that penis to vagina contact?
Yes.
So a second time?
Yes.
When that happened, did you say anything to him about it?
I think
Now, you said that this was Mr. Van Buren that did this to you.
Yes.
Did you recognize Mr. Van Buren if you saw him again?
Yes.
Yes.
Do you see him in the courtroom right now?
Yes.
And can you please point to him and identify an article of clothing he is wearing for the record?
What he's wearing right
Yeah, just point to him and identify an article of clothing he's wearing for the record.
now. He's wearing a mask.
He's wearing a mask over his face. He's sitting at a counsel table next to his attorney.
Yes.
For purposes of this hearing, we ask the record reflect that the witness has identified the defendant, Mr. Van Buren.
Any objection? Identification is noted.
I have no further questions.
Cross-examination.
How did you and Mr. Van Buren first come to know each other?
We followed each other on social media and made friends that were friends with both.
Okay. Do you know the first time that the two of you actually physically got together? And I don't mean sexually, I just mean face to face.
I do not remember that.
Okay, would it have been in the fall of 2020?
Could have been, but I don't think so.
Let me rephrase, it might help. Would it have been a few months, a few weeks prior to the incident you described today?
We started talking a few months before, and then we started dating in October.
Okay. When you said dating, where would you go?
We basically just hung out with friends. I was never really alone. Then I invited him to a Halloween party I had at my house.
Okay. Was that the first time he was ever at your house?
Yes.
Did anything happen at the Halloween party?
No.
Did you tell the police that he tried something? You were interviewed, correct?
Objection to relevance.
Evidence of prior sexual contact between the accuser and the accused is admissible, and it's not, and she's indicating that it wasn't consensual. So I'm just,
Okay, so your question, I guess, is alluding or trying to understand whether or not there was prior sexual conduct, what you're saying?
yes.
And then you're believing that evidence of prior sexual conduct is relevant to the charges here?
The issue of consent, because it's one of the elements. If later it's consensual, then the Romeo and Juliet statute could apply because of the age difference between the two parties. Because it would be eligible for that.
I don't see how prior sexual conduct within that was consensual means that he could have sex with her whenever. So
I can ask the question differently.
thank you. The objection sustained.
Was the incident you described in November that you just testified to the first sexual contact of any form that you had? That the first time?
Yes.
And you did have a party. You said you had Halloween. Was that your first date?
Kinda, not really. My whole family was there.
Okay. And they were there at that party?
Yes.
And did your mother know that you were dating
Yes.
or seeing him? That she met him?
Yes.
Okay. Had he ever been over to your house at times other than at Halloween?
No.
That was the one and only time he was there? Did you say that your mother took you to his house?
Yes.
Okay. And could I assume that your mother then picked you up from the house?
Yes.
Did you ever interview and say that the last time you saw Mr. Van Buren was after this incident?
Yes.
And did you indicate that you By some sort of telecommunication told them that you were done?
Yeah.
Did you ever tell your mother that you were done with him?
Yes, I did.
Did you ever tell your mother about the incident?
I did a few months after the incident.
Was she the first person that you called?
No,
Who was the first person that you called?
my best friend.
And you know about how long after this you said something?
I said something to my best friend about 1 to 2 months after, and then she ended up contacting the principal of my school a little bit after that.
Was there a reason that you never told your mother?
I thought she would think differently of me.
Okay. In your interview, did you indicate that after this occurred, immediately after this occurred, like I think probably within hours or something, that you were crying?
Yes.
Were you crying when your mother picked you up?
No.
Were you upset when your mother picked you up?
Yes.
How did you demonstrate being upset?
I didn't talk, and I stared out the window.
Could you go over again? Who was at the house, at Mr. Van Buren's house when you went over there?
His grandmother, his older brother, and his school sister.
During the interview that you had, you indicated that there was a time when he had ejaculated, if I can say that. Okay. Did you also then tell him that he continued to have sex with you?
Yes.
Okay, after that? Okay, was there any break after the ejaculation?
Yes.
Okay. Okay. So you didn't tell him that he just kept having sex after the ejaculation? When I mean kept, without break, without withdrawing himself from you?
Your Honor, I object to the relevance into, this is a confusing question.
So what's the relevance of the
I'll
question?
move on.
Thank you.
You said 40 minutes later, he penetrated you again, is that correct?
Yes.
Did he threaten you at any time that?
Yeah.
What was the threat at that time?
He said that I better not tell anybody or something. So
Okay. And when was that threat made?
that was made after when we were walking up the stairs.
Did he make any threats prior to having sex? Okay. Did you tell in your interview that at some point that you just consented to it?
No.
What were you wearing?
I was wearing some woolly jeans that I had on and a t-shirt. Can't remember what color it was.
You indicated that when you dated, you go out with friends, is that correct? Do you know the names of any of those friends?
They were mostly his friends. I don't.
You can take a moment, that's okay. She needs a moment. I've already been advised that she might.
That's fine. We can have 5 minute recess.
You want to take a break and drink a water?
back on the record and wish to lend your oath. You can proceed, counsel.
Prior to the sentence, that Mr. Van Buren always acted what you felt was appropriately towards you. And you wouldn't have gone over his house if he had, would you? You indicated that you broke up by telecommunication. What form was that? Was it like a telephone call, email?
It was the text, it was Snapchat.
Okay, Snapchat. And when you weren't physically together, you know, talking face to face, how would you commonly communicate with Mr. Van Buren?
Through Snapchat or FaceTime, text message.
I'm not really very tech savvy. Can those, you know, if those messages can be preserved? Meaning, could you go back and retrieve them?
You could, depending on if they were saved.
Do you know if they were?
I don't remember.
Okay. Remember what Mr. Van Buren was wearing that night?
I know he had a gray t-shirt on.
Okay. I think you said that you had gone over there for dinner. Did you ever have dinner?
Yes,
Do you remember what you ate?
I didn't eat much. It was, I know they had like roasted bell peppers.
Was the dinner before or after you went to the basement?
It was after.
So you were upset at that dinner then, correct?
Yes,
Do you recall anyone asking you if there's anything, a problem?
no,
You said that the first person you told was your friend, but would it be true that the first person in authority, let's say at school, was Mrs. Oakes?
yes,
Okay, and would you agree that was sometime in the spring of 2021?
yes,
Why did you wait so long?
because I felt as though I was nasty and like how I felt after, so I didn't want to talk about it.
Did you say that you had asked him to wear a condom?
Yes,
And did you say that he did not have a condom on? Okay, but he did ejaculate, is that correct? And within you? Did you ever think to go to a doctor?
I thought about it, but I didn't have any signs that I thought I would, and then I ended up going to the doctor after I told somebody.
We know that you told, because you said that sometime in the spring, you told Mrs. Oakes. When did you tell your friend Allison?
I told her before I told my counselor because she ended up talking to the principal. And got the principal involved with her school, and that's when I told Mrs. Oakes.
Okay, so it is your understanding that Allison, fairly quickly after you told her, said something
Yes.
to the school authorities?
Yeah, she said that if I didn't tell somebody in the next week, she would go to somebody, and I never told anybody.
I think you testified that you went downstairs and watched Netflix.
We watched a music video.
Thank you.
Here we go.
No, you're trying.
Thank you, Ms. Wilson, be excused. Yes. Thank you, Ms. Wilson, you may be excused. You can go to the next witness.
There's no other witnesses, Your Honor.
Okay, is the defense calling any witnesses today?
No, Your Honor, thank you.
You can proceed to argument.
Your Honor, we are moving for bind over on the complaint as charged. Give me one moment, I'm sorry. Yes, Your Honor. And I hate to do this without giving the court notice, but it is our intent to move the bind over on the complaint as charged and also add 2 additional counts, alternative counts of CSC third by force or coercion, which would be 750.520D1B. And it would be for the same 2 counts as charged in the original complaint, except an alternative count to reflect the force or coercive elements described by Ms. Wilson.
Thank you.
Really, that's the first discussion now.
Today was a date that was set for preliminary examination. At the time of preliminary examination, Mr. Van Buren, the burden is squarely upon the prosecution to present sufficient evidence to establish probable cause. So they have to establish that there's sufficient probable cause that a crime was committed and probable cause sufficient to charge you as the defendant who committed the crime. It's not a burden that is to be compared to the burden you would face if this matter were to proceed to trial. The burden at trial is also on the prosecution, but then it is their burden to prove each element beyond a reasonable doubt, a much higher burden. This is a very low burden. It's a burden compared to, or that requires more than mere suspicion that a crime was committed. And it's based on the facts and circumstances and evidence presented today at the hearing for preliminary examination. We heard the testimony today of a Kyra Wilson. And she indicated or described an incident that took place on November 2020. At the home that she stated was the defendant's home. There was previous stipulation as to the address of the venue being at 311 West Hodge, City of Lansing, Ingham County, making venue before this court appropriate. She testified that she had been dating the defendant. At the time she was 15 years old, and the defendant at that time would have been 18 years old. She indicated that she was invited over to the house for dinner. The defendant's grandmother, siblings were also present at the home at the time. She was dropped off by her mother. That the defendant's bedroom was located in the basement. He invited her down to the basement under the guise that he wanted to show her something. When she got to the basement, she asked, "What is it that you want to show me?" The defendant tried to take the victim's shirt off. She indicated, she said no. She testified that they began to watch a music video, at which time the defendant allegedly crawled on top of her and took her shirt off, and she testified she tried to push the defendant off, but she was unable to do so. The defendant unbuckled her pants, pulled her pants down, and forced himself upon her, and penetrated her penis to vaginal. She said she was unable to fight him off, although she indicated there was some attempt to do so. She said she did ask, was he wearing a condom, at which time he stated yes, and then afterwards she was informed by the defendant that he was not wearing a condom. And after that incident, she recalled herself. They sat and watched the video again, and that the defendant then asked if he could give the victim a hug, at which time he then again took her clothes off and again forced himself upon her, penetrating her penis to vagina. She testified on cross that that was the first time that she had ever been alone with him, that they had been dating approximately since October. Talking a few months before then, they only had been in settings with other friends or family, and that he had been invited to her house for a Halloween party prior to that. And it was charged in this complaint with 2 counts of criminal sexual conduct, 3rd degree, person 13 to 15. Prosecution is requesting to add in the alternative 2 counts of criminal sexual conduct, 3rd degree, by force or by coercion. Criminal sexual conduct in the 3rd degree at the time of trial will require the prosecution to prove beyond a reasonable doubt, first, that the defendant engaged in sexual conduct that involved entry into the victim's genital opening or anal opening by the defendant's penis, finger, or tongue. Any entry, no matter how slight, is enough, and it does not matter whether the sexual conduct was completed or whether semen was ejaculated. Element B is entry into or the victim's mouth by the defendant's penis. Any entry, no matter how slight, is enough. It does not matter whether the sexual act was completed or whether semen was ejaculated. Or it could be proven by touching of the victim's genital openings or organs with the defendant's mouth or tongue, or it could be proved by entry by any of the one person's body by some object. I think that in this situation described by the defendant, A was as appropriately applied, or most appropriately applied. I believe that the testimony satisfies probable cause as to those elements. I will grant also the prosecution's request to add 2 counts in the alternative of criminal sexual conduct, 3rd degree, by force or by coercion, as the victim testified that she did not grant consent for sexual conduct, and that she did make attempts to push the defendant off at least one point. She told the defendant no. So the matters will be bound over as charged with 2 additional counts of criminal sexual conduct, 3rd degree, in the alternative by force or by coercion. The bind over date will be August 31st. That's not a date that you need to appear in court. That's just the day that they get the file from the district court. Your next court date will be in circuit court, and it will be a pre-trial. Do not need to be arraigned in circuit court unless your attorney makes a motion indicating that an arraignment in the circuit court level is necessary, okay? Do you have any questions for the court at this time?
Nothing from the people here.
Well, I was particularly asking him if he had a question, because he
Oh,
was talking to
no.
his attorney. Okay,
I have questions for him, but
very good. Okay, bond in this matter was set at $15,000 cash surety, and that will continue along with a no contact order. Any additional matters for the record?
Nothing from the people.
Thank you, you're all set.
I believe we will have an exam on the Clemens case. I'd like to go check in with Ms. Wilson really briefly.
Very good, thank you.
Sorry that I didn't, I don't know.
Yeah, so, well, hopefully there's a path, right?
Trying to see what comments. And then Barnes is a waiver. We'll get Barnes.
Yeah.
On the record in the matter of the people of the state of Michigan versus Henry Lee Griffin, file number 22-02030. I'm sorry, is Mr. Griffin in here? No?
He's out in the hall.
Oh, okay, we'll do that. His paper was right here, so I assume he was in here. Don't worry.
Barnes. This is
He's-
Barnes.
This is Barnes, and who is this?
Clemens.
Clemens, okay. And we're running Clemens, correct?
Yes.
Okay, we're on the record in the matter of the people of the state of Michigan versus Jonathan Troy Barnes, file number 22-02051, council appearance.
Chris Martin for people.
And Assistant Public Defender Scott Nichol on behalf of Mr. Barnes, who is present in court.
Okay, thank you. Today's the date that's set for preliminary examination. And I have a note here that there's going to be an unconditional waiver to circuit court. Is that correct?
That's correct, Your Honor. And there's an offer that Mr. Nichols asked me to put on the record.
Okay, can you just let us know?
And that offers for Mr. Barnes to plead guilty as charged in count 2. Upon successful plea, the people agree to dismiss count 1. We expect to work out a sentencing agreement with the circuit court.
Mr. Nichol.
That is a accurate statement of the offer as it stands. And it is Mr. Barnes' desire to waive the preliminary exam today, ask the matter to be honored with circuit court for negotiation to continue, a possible resolution once the case is in circuit court and kill of the agreement can be.
Okay, thank you. Okay, and Mr. Barnes, how are you?
Well, how about yourself?
I'm doing well, thank you. Today was the date scheduled for your preliminary examination, and you heard the offer that was extended by the prosecution. You have the right to have a preliminary examination here in the district court, and you have the right to have the prosecution present sufficient evidence to establish that there is enough probable cause that a crime was committed and enough probable cause to charge you with the crime. Do you understand that?
Oh, yes.
Do you wish to unconditionally waive your right to examination today?
Oh, yes.
You understand that the unconditional waiver means you can't come back later and say, I changed my mind, I want to have my exam. Once you waive it, it's gone. And this matter will be sent over to the circuit court for further prosecution. You understand that?
Oh, yes.
Is anybody making any promises to you to get you to waive your exam?
I know you're on.
Has there been any threats made to you to get you to waive your exam?
I know you're on.
And are you waiving your examination freely and voluntarily, sir?
Yes, you're on.
You waive your name to be made freely and voluntarily. The matter will be bound over to the circuit court. Bind over date's going to be August 31st, 2022. You do not need to appear in court on August 31st. That's the date they get the file from this court. Your next court date will be in circuit court, but it will be a pre-trial. You do not need to be arraigned in circuit court on this unless your attorney makes a motion before the circuit court requesting arraignment. Okay, sir?
Oh, yes, sir.
Do you have any questions at this time? The question's for me, not for him.
Oh, this, was trying to get a PR bond?
He wants to address bond, but do you have any questions about what we did?
Oh,
today?
no, excuse me, I'm sorry, no.
Does he have something else pending?
He does have several misdemeanor files pending in front of your honor.
I'm trying to understand why there's a note on here for no PR 28 days. I don't have that information before me, so I can explain what that was all about. He was arraigned on the 3rd, bond was set at 5,000, 10%. It's pretty low, considering the charges. I'll allow you to make your bond motion.
Yes, your honor. I have been able to have regular conversation with Mr. Barnes. He is appropriate and cooperative during those conversations. He does report to me that he has an address and a phone number. He can make contact with me. And he does understand that he has the other pending matters in front of your honor that he will need to keep making his court dates on. I understand that the bond is low, but it is a bond that he can't post. As Mr. Barnes' sole source of income at this time is SSI, which he is not receiving while he is incarcerated in the jail. So we are requesting that the bond be converted to a PR bond so that he can be released while this case is pending. We have had the conversation. He understands the importance of staying in contact with me, the court, keeping his address and phone number updated if it changes, and making it to each and every one of his court dates so that his cases can keep.
Okay, I see a note here indicating that at the time of Mr. Barnes' arrest, this was his 5th arrest in the last 30 days. That, I'm just telling you what the note says. I'm not asking if you to dispute that information, okay? So it sounds like there's some frequent contact. And obviously, there's some other matters that are pending. I think the bond is appropriately set, so I'm denying the motion for a PR bond. And bond will continue at $5,000, 10%. Any additional matters for the record?
Nothing from the people. Thank you.
Nothing further from the defense. Don't have one yet. 31st of August, record the file. Some judge as soon as it's now. I'll file it on. Oh, yes.
Okay, we can take care of Mr. Griffin before we start the exam. Mr. Griffin here?
Yes, he's in the hallway.
You can bring him in. I'm gonna take care of him before we start the exam.
No problem.
Okay. We're on the record in the matter of the people of the state of Michigan versus Henry Lee Griffin. File number is 22-02030. Council appearance.
Chris Martin for people.
Thank you, Your Honor, and good morning. Jared Austin appearing on behalf of Mr. Griffin. He's present with me at council table.
Thank you. And how are you, Mr. Griffin?
Are you good?
Yeah, well, thank you. Today's the date that is set for preliminary examination. I have a Nolly here. States that the necessary witnesses has failed to appear. The people are moving to dismiss without prejudice. It simply means that if the necessary witnesses later make contact with the prosecution and they're ready to proceed, the prosecution has the right to reissue the charge against you. Do you understand that? Yes. Okay. Do you have any questions for the court?
No, ma'am.
We'll get you a copy of this dismissal and you'll be all set, okay?
Thank you.
You're all set.
Thank you, Judge.
No problem. Thank you. Oh, wait, who's Clemens? Austin, okay.
Behind you.
Thank you.
Qualification. On the record in the matter of the people of the state of Michigan versus LC Lamar Clements, file number 21-03001 FY. Can I have your appearance, please?
Chris Mark for the people.
Thank you, Your Honor, and good morning. Jared Austin appearing on behalf of Mr. Clemens. He's with me at council today.
Thank you. How are you, Mr. Clements? How are you?
I'm all right. How about
I'm doing pretty good. Today's the date that's set for preliminary examination. Is there any preliminary matters that we should address?
None that I'm aware of, Your Honor.
I believe there may be multiple witnesses. I would just ask for an order of sequestration.
How many witnesses do you have?
I think we have 3 here. We expect to call 2,
Okay,
and no one else in the court except for our first witness.
okay, sequestration is granted. Where are your other witnesses?
One's in the conference room over here, one's sitting in the hall on the bench.
Okay. And this is one of the witnesses here?
Yeah.
Okay, so sequestration will be granted. And so that means, ma'am, that you're not going to be able to discuss any portions of your testimony with any of the other witnesses. Do you understand that? Okay. Any other preliminary matters?
Nothing for the people.
I have nothing further, Your Honor. Thank you.
Thank you. And then you can call your first witness.
All right, people call Sharon DeBoos.
You can step right here and then raise your right hand, ma'am.
Up here.
Yep. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
Thank you, ma'am. You can have a seat there. So there's a microphone that's in front of you, and this is my court recorder that's right behind you, and she has to take down everything that's being stated here today. So all of your responses need to be loud and clear so that we can hear them. Also, there's a glass here, so sometimes it blocks our ability to hear if you have a low voice. You sound like you have a softer voice. So try to speak up loud and clear. Make sure your responses are verbal, no heads, nods, and shakes, and and because then you'll hear us ask, is that a yes or no? Okay.
Okay.
Also, if there's an objection by either of the attorneys, you would stop any response. I'll make a ruling on the objection, and then I'll advise you if you can give that response or not. Okay.
Okay.
Please state your first and last name and spell both of them.
Sharon DeBoos, SHARONDA, last name Booth, BOO.
Okay, proceed, counsel.
Ms. Booz, I'm going to ask you some questions about some things that happened in July of 2021. So that's about a year ago. Do you remember that time?
Yeah,
Where were you living at that time?
here in Lansing,
Okay, do you recall your address?
711 West Shaughnessy Street.
And that, okay,
That's apartment A.
and that's in the city of Lansing
Yeah,
in Ingham County, Michigan?
yeah.
Okay. Who lived at 711 West Shiawassee Apartment A with you?
Me and my 3 children.
And can you just briefly say the names of your 3 children?
DeAndre Shepherd, Gervonta Shepherd, Juliana Shepherd.
Okay. How old is DeAndre Shepherd?
As of now, I'm 18.
Okay, but in 2021, he was 17.
Yes.
Is there somebody in your life around this time named Elsie Clemens?
Yes.
And what was your relationship with Elsie Clemens around July of 2021?
Boyfriend.
Okay. Would you describe the relationship as strong, or was it falling apart?
Terrible. Falling apart.
And why do you say that?
I don't know. It's arguments, fights, jealousy, insecurity, both things. It's just a lot.
Now, you said you were in a relationship with Elsie Clemens during this time. Did Mr. Clemens live in your house?
No,
Did he ever live in your house?
never.
Okay. Was he allowed in your house when you were not there?
No,
And why do you say that?
because a lot of occasions we will get into it and don't tell me what the last time he ended up leaving the house, and it's just a lot. He's not known. And then my children there, I don't like nobody around my kids like that. No, like, no, it's just too much. It's too much.
During the time you were dating, did he ever have a key to your house?
Never.
Okay. It's your testimony that he would only be in the house if you were there.
Yes.
Okay. Do you recall some events that happened on July 20th, 2021?
Yes.
Okay. Where were you on July 20th, 2021?
I was at work.
Where's work for you?
Jimmy Jazz in Dearborn, which is Fairlane Mall.
Fairlane Mall.
Yes.
What is Jimmy Jazz?
Jimmy Jazz is the online urban clothing store.
Okay.
So
And so you were there during the day. Was anybody at your house while you were at work?
yes,
Who was there?
my children.
All right. Now, you said this was a tumultuous time in your relationship with Mr. Clemens. What was happening in your relationship with Mr. Clemens at this time?
This was a hard time around this time last year. Very bad time. So it was like we were up and down. You know, I was in love with him. So, you know, he come around, we fight, he leave, I miss him, he miss me. So it was crazy. It was up and down.
Okay, but I want to talk specifically about July 20th. Was there something that happened on Facebook?
We've been getting into it since very long. I was at work, I post something. It's some guy, I don't even know, part of it. LC called me while I was at work on my phone, yelling, screaming through the phone, calling me all types of hoes, bitches, this, that. And I'm like, why? And he, excuse my work language, but who is this nigga that's on your post? I don't know. I still have all that on my phone. I even contacted the guy, was like, my boyfriend is upset because I know you. Anyway, for short. I told LC, just leave me alone, don't come around, because when you get like that, it's hard to calm him down. You know, you gotta come on his own. Next thing you know, I called my boys and I was like, where's LC? And they said, we don't know.
Objection, hearsay.
Objection sustained.
Well, yeah, we can ask more questions. So we're talking about your interactions with Mr. Clemens. We can't talk about what your boys said at the time.
Oh.
So, but we can talk about what Mr. Clemens said.
Okay.
So when you're having this argument, you told him to stay away from you in the house. Did you tell him to stay away from the house?
Yeah.
When you're having this argument with LC on July the 20th, 2021, what did he say to you? What did LC say to you?
He didn't say nothing, really. He was just cursing me out, calling me out to my bitches, hoes, and that was about it.
Okay. At some point, did you go back to your house at 711 West Shiawassee?
Yes,
And why did you go back to the house?
because I live there.
Okay, so this is after work.
Yeah, I couldn't get out for work. So
After I talked to my kids, knew what happened, I called the police. They said I had to call them back as soon as I get in town. So as soon as I got off work, came back home, and then that's when I contacted the police and seen all my belongings gone.
So let's talk about that. What, your house at 711 West Shiawassee, what was the condition of the house when you returned?
It was the same as how I left it.
Was anything missing?
Yeah,
What was missing?
like 10 to maybe 10, 11, 12 pairs of shoes
Okay. And where had those shoes been?
in my room, in my closet.
All right. Did Mr. Clemens say anything about the shoes?
No,
Okay. Was anything else missing besides the shoes?
no,
Okay, so it was mostly shoes that were missing.
yeah,
And these shoes belonged to you?
yeah,
They were in your house when you left for work on July 20th?
yeah,
But they weren't there when you got back.
no.
I have no further questions for this witness. Oh, I'm sorry. One more question. You said that Mr. Clemens was the person you've been in a relationship with around this time.
Yeah,
Do you see Mr. Clemens in the courtroom today?
yeah.
Can you please point to him and identify an article of clothing he's wearing for the record?
It's right there. The jail uniform.
He's in a jail uniform sitting next to his attorney?
Yes,
Right. For purposes of this hearing, can the record reflect that the witness is identified as the defendant, Mr. Clemens?
Any objections to identification?
Without objection.
Identification is noted.
Nothing.
Cross-examination?
Sure, thank you. Good morning. So, as I understand it, the date that we're talking about, July 20th of last year, you were at work that day in Dearborn, is that right?
correct.
Okay. And is that during the day you were working, morning, evening? What kind of shift was this?
It was an auto show. I was a store manager, so I would leave my house at about 9 in the morning, make it there, and I didn't leave until 8 at night.
So around a 11-hour shift or something?
Yes, sir.
And you commuted that from Dearborn to Lansing?
Every day, 2 years.
And when you arrived back home on that day, we're talking about the items that were missing. What time did you approximately arrive home at?
As soon as I got off work, I punched out probably around 7:30 because I didn't have to close on my store. It takes about an hour, 15 minutes to drive here. Was that 7:30? Like 9:30, 10 o'clock-ish, maybe, question mark, somewhere.
So in other words, it was nighttime when you
It
got
was
back.
nighttime and everything. when I came.
And did you call the police when you got back, or did you call them while you were still at work?
I called him both times. When I knew he was in my house. And
Well, as my question was, the first time you called them, you were at work?
I was.
Okay. And roughly what time of the day was that?
I
That you
don't
recall?
know. I want to say around 11, 12-ish. Yeah, I don't know. That was a year ago.
And when you say 11 or 12-ish, you're talking around noonish?
Yes.
And I understand your testimony that you and Mr. Clemens, were you still in a relationship at this point, or had your relationship been ended at this point?
It was on and off. It was on and off.
And you know, on this day, July 20th, you can recall if it was on or off on that particular day?
Off.
And you stated that Mr. Clemens never lived with you at that address in Lansing. Was I hearing that correctly?
Yes.
Did he stay with you there occasionally, though?
Like come spend the night with me, yes. Like come over days, yes. Weeks, yes. He would come with me, yes.
And would he do more than stay the night, or would he stay like several days at a time?
When I was on vacation, he stayed the whole vacation time with me. So, yeah.
And he had your permission to be there then?
When I was there, yes, because I was there.
And did you have a key to your place?
Never, no.
And the shoes that you were talking about missing, you said those were your shoes, is that correct?
Yes,
No men's shoes or no children's shoes missing?
no.
Just have a brief moment, Your Honor.
Absolutely.
And did you and Mr. Clemens work at the same store, the one you were talking about in Dearborn?
Yes,
Okay. And would the two of you carpool together from your place back and forth there to work?
yes,
Was he working there at that time?
no.
When did he stop working?
When he do what?
When did he stop working there?
Stop.
About 2 or
this
3
year.
months,
I'm
2 or
sorry.
3 months before this date?
Yeah.
All right, thank you very much.
Thank you. Rita?
A couple of questions. When Mr. Ross was asking you questions, you said you first called the police from your work.
Yes.
Why'd you call the police when you were at work?
Can I mention my kids? I don't know. They got caught to see what was going on, and when I'm gonna get ejected, my voice is like, I said it's LC there, and then.
Object to hearsay, Your Honor.
Respond to the objection.
I think we're getting to the effect on the listener. Why did she do what she did? We're not really talking about the truth of the matter asserted here.
Objections overruled. You can proceed.
Okay, so why did you call the police from your office?
To check on my children, because LC was around. I called my son. What's going on? Is LC there? They said yes, and I said, well, where is he? And it was like, we don't know, he's going in and out the house. So, and I asked my son what is going on, and that's when I called the police. So he, at the time, nothing was said, was getting taken. That was the question. I just wanted to make sure my kids was okay. And then that's when I'm like, okay, he went in and out the house. I don't know what's going on. Get this man from my house. I called police on him plenty of times just for him to get away. So that's why I called the police. Not saying he stole it, because I didn't know at the time.
I understand.
Get him away from my children. That's why I called the police.
Now, when you did get back to your house on Shiawassee after work, did you report clothing or a television missing?
I did.
And was that missing?
It was, but it wasn't good sales sequence.
Okay. You said a bit about the times when Mr. Clemens was allowed to stay over at your house. Was there anything that, was there any reason for him to believe he had permission to be at your house on July 20th?
Yes,
What would that be?
we were off and on. We were dating.
But
off.
did he have permission to be there when you were not there?
No,
And you weren't there on that day?
and I was not.
Okay. I have no further questions.
Okay, may this witness be excused from the stand?
Yes.
Okay, thank you, ma'am. You may be excused. Also, I want to re-advise you of the sequestration order, okay? So that means you can't talk about any portions of your testimony with any of the other witnesses, okay? Thank you. You may be excused.
Our next witness is DeAndre Shepherd. Okay, yeah, that's true. Thank you.
here, sir. And when you get to the step, just raise your right hand for me, okay? Yep. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Thank you. You can have a seat there, sir. Okay, a couple of rules. There's a microphone that's in front of you, and then I have a court reporter sitting directly behind you. You seem like you have a very light voice, okay? So you need to speak loud. If it feels like you're yelling, that's okay. We want to make sure we can hear you because she has to make a record. Also, we have some plexiglass for safety due to the pandemic, and so it blocks the voice sometimes, okay? The other thing is that you want to make sure your responses are all verbal. You can't do head nods and shakes. You have to say what your response is. You also can't do mm-hs and uh-huhs because she can't write that accurately into the record. So if it's a yes or no question, you want to respond yes or no. If you don't understand the question, you can always say you don't understand the question. If there is an objection from either of the attorneys, I would stop you from responding because I want to be able to respond to their objection, and then I'll tell you if you can give that response, okay? I want you to state your first and your last name and then spell both of them. Okay, proceed, counsel.
Mr. Shepherd, thank you for being here. I'm going to ask you some questions from July 20th, 2021. Do you remember that day? Okay, do you remember something happening with Elsie Clemens on that date?
Yeah.
And who was Elsie Clemens to you on July 20th, 2021?
My mom's boyfriend. I really like a friend. My mom's boyfriend.
Okay, so you saw him with your mom. And do you see Mr. Clemens in the courtroom today?
Yeah.
And is he sitting next to his attorney wearing a jumpsuit?
Yeah.
Right, for purposes of this hearing, we asked the record to reflect that the witness identified the defendant.
Any identification or objection to identification?
Not objection.
Okay, identification is noted.
And were you living at 711 West Shiawassee on July 20th, 2021?
Yeah.
Did you see Mr. Clemens in your house on that day?
I can't hear him.
I see.
Okay, and can you describe?
I couldn't hear anything he said. Could you hear him?
I could not, Your Honor.
Okay, I need you to speak as if you need to, that clock has to hear you, okay?
So,
So yell.
All right, let's just, okay, big voices, right? No, you're fine. You have a soft voice. But the question was, did you see Mr. Clemens in your house on July 20th, 2021?
Yeah.
All right. Can you describe what happened on that date when you came into contact with Mr. Clemens in your house?
He had like, the moment I remember is he had like 2 Jimmy Jazz bags, you know, and then like, I ain't making none of it, you know, because you know, like, he was from and you know, what I really doing.
All right, I'm having a hard time hearing you. I think that the court is too. Remember what we're talking about? You want to yell at that clock, all right?
All right.
So you see him in the house. What did he have with him?
2 Jimmy Jazz bags.
2 Jimmy Jazz bags.
Yes.
Do you know what was in the bags?
No.
Okay. Where was he when you saw these bags?
In the hallway.
In the hallway? And I've never been inside your house before, but what is that hallway? Where does that hallway go?
Like, you got like our room in the hallway leads to my mom's room, and then you got like the bathroom on the first door, and the second door you got like the closet.
All right, and you said he was in the hallway with these bags. Was he close to your mom's room? Was he close to your room? Was he leaving the hallway? Where was he?
About, I'd say in front of the bathroom.
Okay. And had you let him into the house?
No.
Do you know how he got into the house?
No.
Did you give him permission to come into the house?
I think I remember if I did.
but
So you're saying you did not give her permission? You see him with these Jimmy Jazz bags. Did he say anything to you?
Not that I remember.
What happened after you saw him in the house with the Jimmy Jazz bags?
I think he said he was going somewhere. And I said, all right.
And after that, did he stay in the house or did he leave?
He did what?
Okay. Did you see him back in the house after that?
No.
Did you hear any doors slam or anything like that?
No. We was probably playing the game, so a lot of
You say playing the game, what does that mean?
like the PlayStation.
Oh, so you guys were in a room playing a game? Okay. And who are you playing that game with?
My brother.
All right. And when Mr. Clemens was in the house, did you continue to play the game?
Yeah.
So you saw him there, but you weren't really paying attention to him. At some point, did your mother call you?
Yeah.
Why'd she call?
Because, well, I don't really know the reason why she called, but she called me because she wanted me to check her closet to see if like stuff was going on. And I did, and I said, nah, stuff is still here, right? But then she hung up, but then she called back and she said that, check
Objection,
inside the
hearsay.
box.
Did you want to respond to the objection?
I can rephrase.
Thank you, objection is sustained.
All right, so she calls a second time.
Yeah.
And without saying what she said, what did you do?
Wait, second time,
Yeah.
I looked in the boxes. and saw, like, shoes that don't go in those boxes, But
Okay, so is it safe to say that you had some instructions to go check these boxes?
Yeah.
All right, and when you did check the boxes, and these are shoe boxes?
Yeah.
And what did you observe inside those shoe boxes?
like shoes that don't belong in those boxes, like maybe like some heels and like a Nike box, what I'm saying? Shoes that just like different random sort of shoes in those boxes that were there before.
Okay. Whose room was this in?
My mom.
Okay, so were you someone did you know everything that was in that room at this time, or this is your mom's room?
Somewhat, yeah. Like the boxes, yeah, but like the clothes and stuff, no, not me.
I have no further questions.
Yes, Your Honor. Morning, DeAndre.
Morning.
So this day that we were talking about, who all was at the house with you?
My brothers.
Okay. How many brothers?
2.
Okay. And are they older or younger than you?
Younger.
Okay. And you said you recognized and knew Mr. Clemens because he was your mother's boyfriend. Is that right?
Yeah.
Okay. So you'd seen Mr. Clemens many times before. Would that be a fair statement?
Yeah.
And you'd seen him at your house before?
Yeah.
Okay. Seen him at your house before with your mother?
Yeah.
Seen him at your house before when it was just you or you and your brothers?
Like my mom would be there, but then she like go to work. So is that like a yes?
So in other words, your mother would go to work and Mr. Clemens would still be there with just you and your brothers?
Yeah.
Okay. And You know if your house was locked or unlocked this day,
This day? Oh,
the day that we're talking about?
no, I don't know for sure.
When you were there alone with your brothers, was it a routine or habit to keep the door locked or unlocked, or do you know?
I'm sure I could keep the door locked, so yeah, but like sometimes we forget, you know, like for fun, like that.
But usually it was locked. Is that a fair statement? Okay. And what time of the day are we talking about when you said you saw Mr. Clemens there? We talking morning, afternoon, evening?
I think probably noon.
And you didn't necessarily think it was unusual to see Mr. Clemens there at the house that day. Is that right?
Yeah.
And you never called the police at any point that you saw Mr. Clemens in the house that day, is that right?
No.
Okay. And do you know what the total amount of time would be from the time you first saw Mr. Clemens in the house till the time that you believe he left? Do you know what period of time are we talking about?
I'm not sure.
You know if it would be more than 10 minutes or less than 10 minutes?
I'd say less, perhaps, probably.
Less than 10 minutes? Okay. And did you see Mr. Clemens arrive in a vehicle?
Right.
Did you see him pull up to the house in a car or vehicle of some kind?
No.
Okay.
I didn't see.
Did you see him leave in a vehicle of some kind?
I think there was a vehicle outside, yeah, but I'm not sure if he got there.
Did you see Mr. Clemens get into a vehicle of some kind and drive away?
Like him driving? Or
Yes.
like, not him driving. I don't think it was him driving.
And you didn't see anybody else, with Mr. Clemens there that day, is that right?
No, no, no.
And whatever Mr. Clemens was doing there that day, you didn't yell at him or try to get him to stop doing whatever he was doing, is that right?
Yeah.
And you never told him to get out of the house, is that correct?
Yeah.
Okay. You never yelled at him to leave or anything like that, is that right?
Yeah.
Thank you, DeAndre.
No.
Redirect.
No redirect.
Okay, I have a quick question. You testified that your mom would sometimes leave Mr. Clemens in the house when she left for work. Did that happen on this date?
No.
You said no?
Yeah.
Okay, any process yeah, based on that question? Or redirect?
I have no follow-up based on the court's question. Thank you.
No follow-up.
Okay, Mr. Shepherd, there is a sequestration order, so that means that you're under order that you could not discuss any portions of your testimony with any other witness, okay?
Like my mom.
That's correct. All right, do you have any questions about that order? Okay, you're free to go. Thank you. Will the people be calling any other witnesses?
Yeah, at this point, I'm comfortable resting.
Okay, is the defense calling any witnesses?
We'll rely on the evidence presented, Your Honor. Thank you.
We could proceed to argument.
Your Honor, we're just moving for bind over on the complaint is charged. With respect to count one, we believe there's sufficient evidence that that the defendant broke into the house and he did not have permission to do so. He was not granted permission by the homeowner. And that while he was in there, Mr. Shepherd, a minor, was present in the house, and a larceny was committed. I know that nobody saw the shoes actually being taken, but we have a report from the victim that the shoes were missing, and Mr. Shepherd's statement that there were 2 bags that the defendant was holding as he walked out, and that some shoe boxes appeared to have been rearranged with new shoes in the wrong boxes. We also believe that's enough to sustain the larceny in the building count.
Mr. Austin.
Thank you, Your Honor. Your Honor, I'm going to be opposing the bind over request, and I would ask the court to dismiss on both counts. And I think it really comes down to a couple of issues, Your Honor. One, with the initial charge at hand, they would have to demonstrate, one, that Mr. Clemens was there or had entered there without permission. And I think at best, Your Honor, the testimony on that, I think, was rather conflicting. And I don't think it is conflicting to the point that it would rise to the question of fact for a jury to sort through. The testimony is that Mr. Clemens was in a relationship. A witness testified that they were on again, off again. I don't know that it was necessarily clear what the exact status of their relationship was on that day, but certainly that is someone that she had granted Mr. Clemens permission, certainly in the past, to be at her home. And DeAndre's testimony is that sometimes Mr. Clemens would be there, and not just with his mother, but sometimes his mother would leave and Mr. Clemens would be there with just the children. It would have been the routine and habit for them to lock the door, keep the door locked. They couldn't be certain that it was locked on that day. But given all that, Your Honor, and the testimony of the mother that says that Mr. Clemens did not have a key, it seems to me, Your Honor, I think weak at best to suggest that if Mr. Clemens was there that day, that he was there. Certainly, I think would be reasonable for someone in his position to assume that he had permission to be. But even if he didn't, Your Honor, the crux of it really comes down to what was taken, and can they demonstrate that Mr. Clemens stole any of those items. Certainly, DeAndre was the only witness that was there at the home. Mr. Clemens was there, whatever was going on, he was the only one that would have had any type of knowledge to that. He did not or could not testify to Mr. Clemens stealing or taking anything. Certainly, Mr. Clemens was not doing anything that alarmed him or his brothers to the point that he felt it necessary to ask him to leave or to call the police. They never saw him take any items. And I'm not sure with the 2 bags that was testified to that he had, that would have been sufficient to steal the number of shoes that it was that the witness was claiming was taken or missing. So I think there is certainly a defect as it comes to the entry without permission, Your Honor. But again, Your Honor, no one saw Mr. Clemens take anything. There wasn't any admissions that Mr. Clemens made that he had taken anything, nothing to suggest that he was ever caught with these particular items. And for those reasons, Your Honor, I believe their motion for bind over should fall. And I would ask the court to dismiss the case at this time. Thank you.
Mr. Clemens, today was the date for your preliminary examination, and the burden rests squarely on the prosecution to present evidence during the preliminary examination that there's sufficient probable cause that a crime was committed and sufficient probable cause to charge you with the crime. The burden is a relatively low burden. It's not the same burden that you would face if this matter were to proceed to trial. The burden at trial is then on the prosecution to prove each element beyond a reasonable doubt. But this is a burden of more than just mere suspicion that a crime was committed. And it could be established by circumstantial evidence or direct evidence, but the court can use a relatively flexible standard when applying the facts presented today to establish that. Today, you've been here before the court on one count of home invasion first degree, and then it's also an alternative to count one and count two of larceny in a building. Home invasion first degree, if proceed to trial, the prosecution would need to then prove that the defendant broke into a dwelling. Does not matter whether anything was actually broken. However, some force must have been used. Opening a door, raising a window, and taking off a screen are all examples of force to count as a breaking. Entering a dwelling through a already open door or window without using any force would not or does not count as a breaking. Second, the people would need to prove at trial that the defendant did enter the dwelling. It doesn't matter whether the defendant got his entire body inside. If the defendant put any part of his body into the dwelling after the breaking, it's enough to count as an entry. Third, the people will need to prove at trial that the defendant broke and entered the dwelling he intended to commit the offense, in this case of larceny, and that the defendant entered, was present in, or was leaving the dwelling he committed the offense of larceny. And then fourth, the people would need to prove that when the defendant entered, was present in, or leaving the dwelling, there either of the following circumstances existed: A, that he was armed with a dangerous weapon, and or another person was lawfully present in the dwelling. We have the testimony today of both a Sharonda Bruce and a DeAndre Shepherd. They described the incident that occurred on July 20th, 2021 at the area of 711 West Shiawassee Street, Apartment A, located in the city of Lansing, Ingham County, state of Michigan, which makes venue before this court appropriate. Ms. Bruce testified about a relationship that was on again, off again, and an incident that occurred while she was at work in Dearborn at Jimmy Jazz and Fair Lawn Mall. That described a phone call or altercation of some sort, verbal altercation between her and the person she identified as the defendant. She stated that she came home, was later determined that about 10 to 11 pairs of her shoes were missing. The police had already been called to the property to check on the welfare of her children. I think the police were called again after she got back to the property. We heard the testimony of her son, DeAndre Shepherd, who was at the time present in the home with his younger siblings. He stated that on the date in question, he did see the person identified as the defendant in the property. That the defendant had 2 Jimmy Jazz bags when he's in his hand when he saw him, and he saw him in the hallway at the time. He indicated that he was not sure how the defendant got into the house, but that he did not give permission to enter into the home, or didn't give the defendant permission to enter into the home. He said he did look and check shoe boxes at his mother's direction, and noted that the shoe boxes had a random or shoes that didn't belong to them in those shoe boxes. He testified that his mom's boyfriend would sometimes be left in the property with him and his siblings when she was gone off to work. But he did testify that that was not the case on the date and time in question. He also stated that he was unsure if the house was locked. They did try to lock the door, but he couldn't be sure if the house was locked on that date. The victim, Sharonda Boost, also testified that the defendant did not have a key to her house, and that he did not have permission to be in her property when she was not there. And she stated that he did not reside with her at any portion of their relationship, specifically during the time of this incident. As to the elements here, well, the argument, I would say, as to the argument of the defense, they believe that there is an issue as to whether or not the defendant had permission to be in the property. I think it's, from my perspective, clear that she stated that he did not have permission. The son also stated he didn't get permission. Now, whether or not one of the other siblings could have given permission, that I don't know. That could create a question of fact, though, I would believe, for finder of fact. But where I think we actually have an issue is I do not have any evidence, testimony, or otherwise before me that would demonstrate to the court that there was some sufficient force of any type used. I don't know if the door was open. I don't know if a window was open. No one's given me anything. The elements very clearly identify and explain what an opening would mean. Again, opening a door, raising a window, or taking off a screen are examples of enough force to count as a breaking, and entering a dwelling through an already open door, window without using any force would not count as a breaking. And so I don't have enough evidence to establish if there was enough force or any force used for him to enter into the property, and so count one would be dismissed. Count two, larceny in a building. At the time of trial, the prosecution would have to prove beyond a reasonable doubt the defendant took someone else's property. Second, that the property was taken without consent. Third, that the property was taken in a building, in this case, an apartment or a home. Fourth, that there was some movement of the property. It does not matter whether the defendant actually kept the property or whether the property was taken off the premises. Fifth, that the property was worth something at the time it was taken. And sixth, that at the time the property was taken, the defendant intended to permanently deprive the owner of the property. We've heard here again testimony that the victim and the defendant were in an on-again, off-again relationship, and that she believed that she'd obviously instructed her child to go and check her shoes to see if there was anything missing, after seeing that the defendant was in the home with two Jimmy Jazz bags. Also, for the clarity of the record, I think the victim testified Jimmy Jazz is a clothing store, urban clothing store. Nonetheless, her son did testify that there were, it would appear to be a mix-match for random shoes placed in different shoe boxes. Ms. Bruce testified that 10 or 11 pairs of her shoes were missing. The shoes did not belong to the defendant. She did not have permission to take those shoes. I think that there's sufficient probable cause as to count two, larceny in a building. That will be bound over to the circuit court for further proceeding, for a bind over date for August 31st. We do not need to appear in court, Mr. Clemens, on August 31st. Is the date that they will receive. The circuit court will receive the file from this court. Your next court date will be a pretrial date and circuit court. And your attorney will be made aware of that date. He'll be in contact with you, okay?
Yeah.
You do not need to be arraigned in circuit court unless your attorney files a motion indicating before the circuit court why you need to have another arraignment. Do you have any questions right now? Okay, bond in this matter was set at 7,510%. There's also a no contact order in place that will continue. Any additional matters for the record?
Nothing from the people.
Let's go back, Mr. Clemens, Your Honor. Thank you.
You're all set.
All right. Good talk to those folks. Yeah, I don't, it's a hard, obviously, you see the dynamic, so.
Yeah.
I wouldn't say it was a hard time, they just like.
Okay, all we have left are PCCs.
Yeah, and I will probably appear by Zoom for those.
Oh.
But I was going to, before I go back, I'm going to speak to Mr. Bigelow to make sure that we take off the ones we've already done by email. Things like
Okay, I just see something over here on Nicholas Noko. What does that mean?
What's that?
This is Noko.
Nicholas.
Yeah, I'll ask Mr. Bigelow what that means. I don't know what that note means. Okay, well then we'll, it was for his PCC. Which James Nicholas. The Noko? Nope, on that, I don't know what that means. There's no call in our file means no contact, so I don't know what that means here. Unless maybe they want to go, well, no, given the charge, I don't see what that would be necessary. No contact. Yeah, Miss Donnelly didn't have contact with her defendant. Oh, okay, sounds good.